It is illegal to possess drugs without a prescription if they are considered controlled dangerous substances and listed in the Louisiana statutes. Louisiana has placed these drugs into different schedules, which are Schedule 1, 2, 3, 4, and 5, depending on how dangerous the drug has been determined to be. If you do not have a valid prescription to possess these scheduled drugs, then you would be in illegal possession of the drugs. If you have a valid prescription, obviously you can possess the scheduled drugs. You would then be in legal possession of the drugs. If you give a prescribed drug to a friend, you could be charged with distribution of drugs, and your friend could get charged with illegal possession of drugs. Drug possession can be actual, joint, and/or constructive possession. These are legal terms you'll only see in the court setting, really. However, they're important to understand for any defenses. The defendant would be in actual possession of drugs if the drugs were on his person, which means he actually had the drugs in his pockets, cigarette pack, or in his hand. This is the easiest scenario for police and prosecutors to prove possession of drugs. Getting a drug possession charge dismissed when there's actual possession may be the most difficult way. For example, a defendant could argue that their brother put the drugs in their pocket when the cops pull it up, and so the defendant didn't intentionally possess the drugs on his person. Whether this defense would actually hold up in court remains to be seen. I find most people are confused about the concept of joint possession of drugs. Joint possession of drugs means that the drugs could be possessed by more than one person. It is a theory the prosecutor tries to use to get someone or multiple people convicted. For example, let's say a car is pulled over with two people in it. There's a bag in the back seat with a pound of cocaine in it. Neither person claims ownership to the police officers. Both are arrested. The prosecutor will likely charge both people with possession of the drugs as joint possession. It could be that they went in together to buy the cocaine, and so they both have ownership rights in the drugs. Unless there are some other facts the defense could present to show one of the defendants didn't have ownership of the drugs, then it will be hard to get the drug possession charge dismissed. Nevertheless, if there are facts present to show the passenger was simply riding in the driver's car and didn't have any dominion and control over the drugs, then this is a good defense to getting the drug charge dismissed. This is a common scenario and believable. Just because someone is riding in a car with another person does not mean they possess everything in the car. If the drugs are not in the defendant's actual possession, not on him, but the police and prosecutor think they can still prove that he possessed the drugs, then the theory they use is constructive possession. In the previous example, the two people would be considered to be in constructive possession because the drugs were not actually on them. The prosecutor would be asking the jury to assume they were in possession of the drugs since they were in the car with the drugs. Now let's discuss a common example of drug possession in a residence. Many arrests occur when police enter a residence either through knock and talk, hot pursuit, or search warrant, and they make arrests of multiple individuals. This drug house may be leased to one individual with only him living there, or others crashing or living there. These cases can get sticky because there could be multiple drugs found in different areas of the residence. Cops will sometimes try to question everyone to determine who will confess to possession which drug. Other times they will just arrest everyone and leave it up to the courts. If a defendant is found in the back room of a residence he does not live in, we like to argue the drugs found in the kitchen or living room are not his because he doesn't live there, and the owner or dealer possesses those drugs. There's no reason to believe the defendant visiting the house is in possession of another man's supply. Just because the visitor is in another person's house where illegal drugs are present does not mean the visitor owns and controls those drugs. Is it reasonable to assume the visitor of a house owns the TV, the computer, or the microwave? Well, he doesn't own the drugs either. Therefore, he is not in possession of those drugs. This is a way to get the possession charge dismissed with the district attorney. On the other hand, the owner or tenant of the resident could argue that the visitors to his house, they brought the drugs, and so those drugs were not his. He had no right to those drugs. He didn't buy them. Consider this. If a woman comes to your house holding a purse, the purse doesn't become yours because it is now in your house. She still has ownership over that purse. You have no rights to it. You do not possess that purse. Case dismissed. There are many more defenses, both factual and legal, to drug possession cases. But I hope this video sheds a little light on how to defend drug cases. If you or someone you know has received a drug possession charge in Louisiana, give me a call. I'd be happy to help.